Probate has a bad reputation, and most of it, well, it's deserved. I'll tell you why, because it's slow, it's expensive, and it's public, meaning anyone can walk into a courthouse after you've passed away and they can look at what you've owned. Because when your will gets filed, eventually so does a listing of your assets. But understand this, at the same time, much as we hate probate, it's not there to punish families, it's actually there to protect families, right? Because when you're gone, who's to say somebody doesn't walk up and say, well, I can transfer these assets, or I'm the beneficiary of them. He meant for them to all go to me, all right? So we want to protect beneficiaries to make sure the fraudsters can't get after your assets. And so that's why probate is there. It's there to protect. Now, the problem with the way it's set up, of course, it's geared towards enriching attorneys. That's why, generally speaking, 3 to 7% of a state can go to the attorney for probating the estate. And talk about time. They say on average it's 20 months. I know when my grandmother passed away, she passed away with a will. It took nearly 5 years to wrap that estate up. And of course, it was a public record. And this is the thing that teaches people that, wow, this was an uncomfortable process to be stuck in. I don't want to go through that again. So oftentimes people will think, is there another way? And many of them just want to skip the trust altogether, and they'll say, hey, can I do something simpler? Yeah, there are other ways to do it. Okay. However, the problem is most of them will cost you and you don't even see it's coming. So in this video, I'm going to walk you through all 7 ways to bypass probate, and then you can make a decision at the end which way you want to go. All right, let's get started. Okay, so option number 1. It's a simple option, right? You give it away while you're alive, right? Sounds really clean. So here's what I'm going to do. All right, I'm right here, and I've had people approach me about this before. They have their personal residence, and they have 2 children here. And what they want to do is they'll say, listen, if I understand that if I own this house when I pass on, that it's included in my estate and has to go through the probate process. So instead, I'm going to gift it to them today. And they're going to allow me to continue living there with, of course, their permission because they're now the owners. And so this becomes the problem with gifting away your assets. When you transfer your house to them and it's no longer in your name, it's now in your kid's name, even if you're allowed to live there. The problem is that their problems can become your problems. Let's assume your son here is going through a divorce with his wife. Now, this asset is part of his estate. That's something that he owns. So now your living conditions here, they might change in this property because now the ex-spouse becomes an owner of that house and she wants full fair market rent for that property. There's also a tax problem when you do this, right? If your children, when they inherit your house when you pass away, they get a step up in basis. So that means this, that if I bought this house for $300,000, okay, and then when I pass away, the value of this home is $1.6 million, my children, when they inherit it through my estate, their tax basis is jumped to the 1.6. That means they could go out and sell it tomorrow for 1.6 million and pay 0 tax. But if I gift them the house today, they take my tax basis of $300,000, and after I pass, they said, all right, Dad's gone, let's sell the house. They sell it for 1.6 million. They'll have $1.3 million in gain, of which they'll have to pay tax, let's say at 20%. Hey, look at that. That's some sizable money. $260,000 is taxable when they sell that property. Okay, so this is a problem with outright gifts. You're giving the asset to someone else. If they're involved in a lawsuit, you risk losing the asset completely to their lawsuits. So, other than the gift, what is the next strategy that people will employ? This one, joint tenancy. Okay, so what does joint tenancy mean? Joint tenancy is referred to oftentimes with rights of survivorship, okay? And it's pretty popular on the list of how you can bypass probate. And it works as follows. Let's say we have Mom here, and she wants to name her daughter as her joint tenant on her home. So she transfers title to both of them as joint tenants with rights of survivorship. Now, the reason you're doing this is so that when Mom passes away, title to the property vests 100% in the surviving tenant. Just happens like that. They own it 100% outright. Okay, now, the problem with this, again, goes back to the issue we also had with just gifting an asset outright. Before mom passes, all right, when this asset is held in both their names as joint tenants, if daughter here is involved in a lawsuit or a divorce, she owns this house, an unrestricted part of this home. So mom now is subject to the whims of the ex-disgruntled spouse, and that can tie up the asset that way. So that can create a problem. If the daughter, maybe she started a business and she has to file for bankruptcy, then that asset would be drug into the bankruptcy. So that's a concern that I have. The liabilities with your joint tenant now become your liabilities. But let's assume you're watching this video and thinking, well, that's not a problem for me. Stable marriages, they don't engage in any business activities where they're going to go bankrupt, whatever. Here's something that people do not factor in. Let's assume that you have another child, okay? You had 2 children, 2 daughters. Now, your intention was that when you pass this house to be split evenly between the 2. But when you put your daughter on as a joint tenant, and many times people do this for control. They think as well, something, if I'm incapacitated, she can then control it and pay property taxes and things like that. But you're also doing a disservice to your child and this other child. Because now the survivor joint tenant owns the house outright. So what does that mean for the other daughter? She gets nothing. In fact, my mother-in-law proposed this a number of years ago to my wife. She said, this is probably going on 18 years. She wanted to make her a joint tenant. And I said, well, what about her sister? I said, you're upset with her? You don't want her to receive this? Oh, no. I expect Tracy to give her half the estate or half the asset when I've passed. So now what you've done is you've taken an asset here, you run it to Tracy as a gift, so now she owns it 100%, then she has to turn around and gift half of that over to her sister. And so now she has a gift tax issue that she's facing because we wanted to set it up in joint tenancy to avoid probate and not use a living trust. Okay, so that's option number 2. Here's option number 3. Beneficiary, I'm just going to put Benny, designation. So with option number 3, what you're doing there, and it's actually pretty good. Okay, so this is one that I think makes a lot of sense in specific situations. So you're over here and you have a savings account. All right, let's say I have $500,000 in my savings account. Now, if I keep that in my name and I pass away and I don't have a trust or anything set up, then that would have to go through probate. So to avoid probate on my savings account, I call up my bank or my broker and I ask for a beneficiary form. I want to designate a beneficiary for this account when I pass. Sometimes it's called a payable on death or transfer on death, where you name a person that when you pass away, or 2 people, that when you pass away, the funds held in that account will pass to them immediately, okay? So if I had a couple of kids, then I would name my 2 sons as my designations. And so when I've passed, then this would be split between them, whatever is within that account. It goes right to them without any delay, and it now becomes their money. Now, what's the problem with this one? Okay, well, it depends on this. Okay, what are their ages? Okay, this strategy does not work with minor children, children that are still not yet mature enough. Okay, because essentially what you're doing then, let's say it's an 18-year-old, you pass away unexpectedly, you're killed. Now your 18-year-old receives $250,000. What does that mean to an 8-year-old? It means a brand new, not a Ferrari, you wouldn't be able to get that, but let's say it's a brand new BMW 5 Series, 6 speeding tickets, and then you're being bailed out of jail within 2 months. Why? Because they're not mature enough to handle the funds. So that's a problem you have. And then the other issues we run into again is that when these funds pass directly to them, let's say this one is involved in a lawsuit right here. So all of a sudden the creditor knows that, hey, they have $250,000 more that I can go after. Or if there's a judgment against him, then it'll attach to those funds. You see, when those outright passes that happen here with the beneficiary designation occur after you've passed away, there's no controls to say, look first here and say, hey, do we have a problem at the beneficiary designation level? Is this beneficiary stressed in any way? If they are, then let's hold the funds until they've taken care of the stressful situation, meaning a lawsuit or a divorce, and then we release them so other people can't gain access to them. Now, it's not to say I don't recommend this on occasion. There are situations where a parent has zero assets other than their savings account, and maybe they're in some type of assisted living. Yeah, if you've got one child, maybe two, name them as beneficiaries, and then it solves your problems in those scenarios. Okay, what is the next one? Number 4, transfer on death deed, or a ladybird deed. Okay, so we'll call this one transfer on death deed. Okay, so what does that mean? It's similar to what I just talked about, okay? Rather than using a beneficiary designation, okay, what we're doing with the transfer on death deed, it's operating the same way, but it operates for real estate, okay? So you record a deed today that says, while I'm alive, the house is mine. Now, when I pass away, it goes to this person. So there's no probate involved there. It just passes automatically. And it's revocable. So you can change your mind later on and say, hey, I want it to go to someone else. Then you could just designate someone else. Now, it's really clean and easy to do this. The thing about this, though, is that it's not available in every state. All right, and the rules vary widely. So you got to make sure you're doing it the right way. And it really only solves for this one asset. Now, the problem you have on this transfer on death is that if there's a mortgage on the property, right? So when that automatically passes to this beneficiary right here, if they have really bad credit, all right, then there can be an issue involved here. And if there's multiple beneficiaries, there can sometimes be issues with this type of planning tool. Okay, now the biggest problem with this that no one ever discusses is they're only thinking about the death. What happens if you're incapacitated, right? So now you're incapacitated, you need to get care for 10 years. And so here you are laid up and you're in a home that is there to protect you. What has that transfer on death deed done for you? It's done nothing, right? Because it's still in your name. And so you don't have anybody that can control that property without going to court and being named a guardian to be able to take control over that asset. And so I would be really careful about using this type of plan because, again, it's a simple plan, but it doesn't take into account unforeseen circumstances that can come up in the future. Now, option number 5, okay, is to do this. Place everything in an LLC. And literally, I've seen people tell me this is their entire plan. I'm going to set up a limited liability company here, and I'm going to put all of my assets in here, my savings, my stocks. And get this, I'll see them do this. Their real estate would go into this one limited liability company. All right, and they lock it all up in there. So I'm not even talking about the asset protection problem we're creating here. So the issue is not understanding what an LLC does and does not do for probate. You see, a limited liability company, it's a separate legal entity, okay? You own the LLC, and when you pass away, what you're passing on to your beneficiaries, right, is your ownership in that limited liability company. We call that membership in an LLC. So if you've set up an LLC, you're a member, okay? Now, with the right type of operating agreement, you can pass an LLC to beneficiaries. It can bypass probate completely. So that's possible with the successor beneficiaries that can be named or successor members in a limited liability company operating agreement. However, you have to be careful of the types of assets you use for this. So you don't want to put your personal residence into an LLC and use this strategy, because if you do that, you're going to use your home sale exclusion when you go to sell the property while you're alive, the 121 capital gain exclusion. You're also going to lose your homestead exemption on the property. So those are really important things that you want to keep in your own name, or the benefits you want to maintain personally. And by putting your home in an LLC, that's a bad call to do. So I think the LLC, maybe it has its place for certain types of assets to set it up this way. But again, by using the LLC, once that transfers, okay, there's no more control or protections for these beneficiaries. But it can be done if you wanted to do that. Okay, so the sixth option is referred to the charitable life estate. Okay, let me just write that down here. Charitable life estate. Now, you don't see this very often, but it's out there. And the way it works is as follows. You do this typically with your personal residence. So here's a charity over here. And what I'm going to do is I'm going to donate my house to charity. But there's with some strings attached. You see, with this one here, when you donate your house to a qualified charity, you retain the right to live in that property for the rest of your life. Now, in so doing, you're responsible for property taxes, you handle the upkeep and the insurance, etc. And then when you pass away, the house belongs to the charity automatically. Now, you're wondering, why would you do this? A lot of times people will do this when they have a house that has a lot of appreciation in it, because they're going to get a tax deduction for this by making this for the remaining value of the property. So that makes a lot of sense for people that need a tax break. And it does skip probate for sure. So if you're already planning to leave your house to charity, you don't have kids that you want to leave the property to, you might want to look at this particular strategy right here, because what I see happen a lot is that people will then pass away, and in their estate plan will say, all right, this house is going to go to charity after I've passed. And so their deduction doesn't benefit them while they're alive. So if you mean to transfer your home to charity, then this is one of those that you might want to take advantage of. Now, here's a drawback to it. Once you sign this deed over, you can't change your mind. You can't switch charities if your priorities shift, all right? You can't sell the house if you decide to move into assisted living, and you cannot borrow against it. So if you need this asset, you think for the future, once you enter into this deal, it's locked in stone and you can't do anything else with it. Okay, so option number 7 is the small estate threshold. Okay, the small estate threshold. And what is this? It's not really a strategy, it's just more of a backstop. And I've used this a few times for clients that have come into us that did not have a living trust and they were looking to probate their assets. And so essentially what it means is this, is that if you have a small estate under a certain dollar limit that is prescribed by your estate, there is a process to handle this. And so if your assets are under the probate level, then your family can use, instead of the full probate, an affidavit they file called an affidavit of small estate. And so it operates like a full probate, but it's really faster and cheaper. Just make the one filing, say, hey, we don't meet the threshold, and it's no real property involved here. It's only account. And what it means is it gives you quicker access to the funds, and you can transfer them on right away. So for most folks, if you own a home, as I stated, it doesn't work. But for those that have small accounts, it could be an option for you. But again, the thing about estate planning is that when you're setting it up, you want to make sure that you're protecting yourself. And everything that I just drawn out for you and shown you ways to do this, they all have an inherent flaw. And that flaw is that nothing is protected while you're alive. Incapacity, right? That's why we talk so much on my channel, my partner's channel, about the benefits of using a living trust, because these are all strategies designed to transfer assets when you pass, and nothing talks about what do you do while you're still here, but you can't physically be here mentally because you're incapacitated. The other thing about it, of course, and I think that's even equally important, is you heard me mention this several times, that once you've passed on, those assets, and with these types of strategies, go like that. Right? There's no control there. There's no protection mechanism. So if your beneficiaries are going through a difficult spot, you just may have increased that difficulty. Think if they were involved in litigation, in a lawsuit, and they lose their assets. and there's a judgment that's been entered against them. And what's going to help them move out of that and then start getting their feet back under them is that inheritance you've left to them. But because you chose one of these strategies, it's going to go to them outright, and the creditor swoops in and takes it. But if you set it up in a trust with a plan in place, then what you're doing is you're making sure that, hey, I can help that person get back on their feet and do it in a way that that creditor will not have access to these assets. That's exactly what a living trust does. It closes these trap doors that I've been talking about. You stay in control while you're alive, and you're essentially in control after you've passed on. You can do the buying, the selling, the refinancing of your assets, your homes. Okay, it's not treated as a separate taxpayer. It doesn't change your tax return. There's just so many benefits of having a living trust that when I hear these other strategies, at the very end, I look at those and I say, hey, they're probably not the right move for about 95% of the people that we work with here at Anderson or that I run into. And so if you want to have a conversation about your estate plan and look at what you should be considering with setting that up, go into the show notes below, and in there you will find a link for a free strategy session. We can talk about your estate planning, how to set it up the right way to make sure you get the most benefit of putting a plan in place, and you'll be amazed on what it can do for you. All right, everyone, I wish you the very best with your planning, and take care.